Okay, I see Mr. Silverberg and I see Mr. Thomas. Mr. Thomas, we are ready for you. You still haven't unmuted, Mr. Thomas. There you go.
Now, may it please the court.
We can hear you.
Thomas, and I represent the appellant, the estate of Albert Joseph Albericchio Sr., through his two sons, the co-personal representatives, Vincent and Albert Albericchio, and the appellant wishes to reserve 5 minutes for rebuttal.
Very good, thank you.
This case involves a court order and an interlocutory appeal of that order granting a motion to compel arbitration. The arbitration agreement is purportedly signed by or through the authority of a power of attorney. So the case involves specifically this court's interpretation of that power of attorney and the authority under it, and therefore the review is de novo. In addressing the power of attorney, it's necessary to address a little bit of statutory history. In 2011, there were significant changes, actually an overhaul to Florida's Power of Attorney Act, and the courts labored prior to.
So we've read the briefs and the statute and the power of attorney. And as I understand your argument, as it relates to the statute, the 2011 amendment, it is that this power of attorney insufficiently conveys the specific authority to sign the arbitration agreement. Am I right?
That's correct in part, Your Honor. It also includes limitations on the authorities of the power of attorney, which will be inconsistent.
And what are those limitations?
The limitations are specified in the power of attorney. In particular, let's get past this. The durable power of attorney is one regarding healthcare.
Well, that's the title, but it covers more than healthcare. And we know that titles are not dispositive or binding to the exclusion of what might be in the contents of the agreement. So what else?
I'd like to address the title as well as the content. The title itself says it's a power of attorney for healthcare. And then there are 3 paragraphs appointing and creating the durable power of attorney for healthcare. And then there are 4 substantive articles conveying powers and a 5th administrative article addressing such things as severability, governing law, and reimbursement.
And so I think it would be good for us to focus on Articles 3 and 4 here.
All right, Your Honor.
I'm sorry, 3, 4, and 5, 3 and 4, and to some extent 5. In Article 3, the power of attorney confers upon the agent the ability to make all necessary arrangements, including nursing home. And Article 4 allows the nursing home to rely on the actions of the agent and the representations. And Article 4 also authorizes the agent to seek actual and punitive damages for any wrongs that occur, any negligence, with any entities defined sufficiently broadly to include nursing homes. And it also, Article 5 authorizes the agent to sign, execute, and deliver any contract or document that may be necessary, desirable, or convenient or proper to exercise any of those powers. So the agent can bring a lawsuit, is empowered, which the agent has done now as in the capacity of the personal representative, and I'm just having a difficult time reconciling where this limitation that you rely on appears here, because to me, reading the document in its entirety and reading those provisions together, and there's certain other ones that are consistent with this that grant pretty broad authorities, and then looking at the statute, which certainly we're not going to contend, I don't think you would credibly contend, that this power of attorney didn't authorize the agent to sign a contract, sign the residence agreement with the nursing home. The arbitration agreement was optional. he had arguably had the discretion. And in subsection 4 of the 709-2201, if the subject over which authority is granted in a power of attorney are similar or overlap, the broader authority controls, subject to 2202, which doesn't seem to be applicable here. So I'm trying to find out where is the beef on why we should interpret, why the trial judge got this wrong, and why we should interpret this power of attorney in a manner that would preclude the agent from signing the optional agreement consistent with the power to put the gentleman in a nursing home, to execute whatever document he deemed appropriate and necessary, convenient, and that he also was empowered to make decisions about bringing lawsuits for things like negligence, which arbitration is a place that could end, as opposed, that he could waive the right to bring that suit in a judicial tribunal.
Your Honor, with regard to the right to access to the courts, that is a very limited right to access to the courts. It's consistent with statute 709, which is cited in the brief, the remedial provision in subsection 6 of 21203, in which power for the power of attorney to seek redress with the courts and get either an injunction or damages brought about by only the failure of someone who should acknowledge and should respect the power of attorney and the authority they're under, refuses or willfully fails to follow the instructions of the attorney, in fact, the grantee, the agent. It is not a power to seek dispute resolution for property claims. It is not a right to redress torts that don't consist of a failure to acknowledge and abide by the authority granted under the power of attorney.
Well, that to me seems like we're going pretty far afield here. The document, which is the primary place we're going to look for what was intended here, it gives the agent the authority to resort to courts, and your client certainly isn't disputing that authority was properly granted or that the document confers it. And reading those provisions together with the broad provisions that are in Article 3 and 4 concerning your client's authority to make arrangements for this gentleman to stay in a nursing home, it gives me a fair amount of concern as far as reading out the right to sign an optional arbitration agreement, which would fall, or at least arguably would fall within the provision that authorizes the agent to execute all documents that may be necessary, desirable, or convenient in order to exercise any of the powers described in this instrument.
Your Honor, that authority to exercise documents is pursuant to the powers, and those powers are very limited. It doesn't expand on those powers. It allows a power of attorney to exercise the documents that would facilitate getting admitted into a nursing home. And it's been held.
I'm sorry, I don't mean to argue with you, but I do want to focus on the language. The power, he has a broad power to place the gentleman in a nursing home and to be relied upon in doing that. And he also has a broad power to execute any contract or other document that may be necessary, desirable, convenient, or proper in order to exercise any of the powers described in this instrument and to incur reasonable costs. So if I'm reading that in conjunction with the provision of Article 3 and 4 about how he can exercise the power to place this gentleman in a nursing home, I don't see the limitation that you're articulating.
I would draw the court's attention to the Manor Oaks case as well as the Estate of Irons case, which is.
Well, the Estate of Irons is, I think you've got a tough sell there, because in that case, if I'm not mistaken, the grantor of the power of attorney reserved the right to sign all documents. So that's a limitation on that holding that is going to make it distinguishable from this case.
Your Honor, I would disagree with that interpretation of the case. In fact, what the grantor retained was financial responsibility, liability for the signature of these documents. And immediately thereafter, in the power of attorney, she says all parties, all third parties, including insurance companies, physicians, pharmacists, healthcare facilities, clinics, hospitals, and all other providers of my medical care shall comply with my surrogate's request for information and accept any documents my surrogate signs for me. She has authorized a surrogate to sign, but she remains solely financially responsible for the bills that come out of those contracts, solely financially responsible for the costs associated with it. It's not going to be her power of attorney. That the argument that it withholds the right to sign is inconsistent with the actual terms of that durable power of attorney. So when we look to Irons.
So I'll take your argument on Irons, and let's look at Manor Oaks, where we explained that.
Judge LeBrick, can I interrupt for 1 second? Because I'm reading Irons again, and it has language in it that says, I alone shall be liable for signing admission or treatment papers. It's not simply a limitation on payment responsibility, is it?
I think if you finish that statement.
I alone, and then it goes on, as I alone and not my surrogate shall be liable for signing admission or treatment papers for my health care, as I alone shall be responsible for such costs. So there is no authority given to the agent to execute admission documents. So I just wanted to bring that point up if I'm missing something, but I know Judge LeBrick wants to go to the other case. So I just want to make sure I understood where you are on Irons.
On the prior page in Irons, on page 397, just before you get to the enumerated paragraphs, is where they direct third parties to accept any documents my surrogate signs for me.
Right. And then the agreement says, but they can't sign admission documents. I alone have that responsibility.
It says, I alone and not my surrogate shall be liable. Shall be liable for signing these documents, meaning financially responsible. The second half of that sentence is that as I, meaning consistent, explaining what the first half says, as I alone shall be responsible for such costs, meaning the liabilities that arise out of those contracts.
Very good. I'll turn it back to Judge LeBrick. Sorry about that.
And thank you. And I wanted then to go to Manor Oaks, which is a more recent decision post the 2011 amendment, and I think is probably more directly applicable here generally as well as on this record. And there we explained that a trial court correctly compels the enforcement of arbitration provisions where the POA either makes a specific grant of such authority, and this is the part that I would like you to address, or unambiguously makes a broad general grant of authority to the attorney. In fact, I don't see any ambiguity in the broad grant of authority in Article 3 and the related provisions that authorize the execution of documents deemed necessary, convenient, or proper here.
Your Honor, Manor Oaks deals with, and this is the beginning of the second paragraph of the opinion, a May of 2009 durable power of attorney. That's when it was created. So it is governed by the pre-2011 amendments and changes.
Understood, but what difference does that make now?
When interpreting that power of attorney, you have to look to the statutes that existed at that time and the analysis that applied. In fact, there was a statutory creation of a broad property rights power in any power of attorney that would allow, that included choses of action.
Well, so to stick to the very focus that we have here, in what way does the 2011 amendment to 2201 that says an agent may only exercise authority specifically granted and authority reasonably necessary to give effect to that specific grant of authority? In what way is that inconsistent with what the holding of Manor Oaks was? Is that, doesn't Manor Oaks effectively express the same standard? And here, if you've got a broad, and by the way, if anything, the 2021 amendment that says if subjects over which authority is granted are similar or overlapping, the broadest authority it controls. And we've got similar and broad overlapping authorities.
The outcome of Manor Oaks is not inconsistent with the change in the statute. The analysis where they go seeking some broad general authority, which under the current statute is not a power that's conveyed by the instrument. It has no weight or effect. Broad general grants of authority are inconsistent with the new statute. It is apparent that the statute is intended for everything to be spelled out with two exceptions.
You're telling me that when the legislature says if you have overlapping subjects, the broadest authority controls, means that the legislature wanted the narrowest authority to control?
No, when it says the broadest authority controls, if you have, well, I will tell you that is inconsistent with the first paragraph in the new statute, which says in particular, excuse me, Your Honor, that the—
Sir Thomas, as you're looking at that, I'll leave you your 5 minutes, but go ahead and answer that question. And unless there are further questions, we'll turn it over to your opposing counsel.
In subsection 1 of 709.2201, that specifically states general provisions in a power of attorney which do not identify the specific authority granted are not express grants of specific authority and do not grant any authority to the agent. And they give an example, such as a provision purporting to give the agent authority to do all acts that the principal can. That, I believe, is a clear statement of the current state of the law as to express broad grants of authority. Thank you, Your Honor.
Very good. Thank you very much, Mr. Silverberg.
Thank you, Your Honor. May it please the court. My name is Jerry Silverberg, and I have the privilege and honor of representing Palm Garden of Pinellas, LLC, and Palm Healthcare Management, LLC. I'm going to skip going over and reviewing the facts because I believe that the facts have been set out in the briefs, and I think that the court is fully familiar with the facts. I would like to point out two things before I proceed with an argument on this, and that is that the first paragraph of Florida's statute chapter 709.08 subsection 6 that was amended in 2011 reads in pertinent part, except as provided in this section or in other applicable law. That's a qualifying term or phrase, or in other applicable law. An agent may exercise authority specifically granted to the agent in the power of attorney, and any authority reasonably necessary to give effect to that express grant of specific authority. So we got not only general authority, but specific authority. But the qualifying language, or in other applicable law, I may suggest to the court, is referring to contract law, that which we all learned in our first year of law school. And the contract law is such that it applies to the construction and interpretation of the powers of attorney as it relates
So
to—
your argument is the legislature knew what the state of the general contract law was when they enacted the 2011 amendments, and that law continues by virtue of this express phrase in the very first sentence of subsection 1. Let me ask you the question. It obviously would have been better for your client if the power of attorney specifically authorized the agent to sign an arbitration agreement. as part of the nursing home admissions process. And I think the crux of your opponent's argument is that it doesn't make such a provision. And in fact, it generally authorizes your client to sign, nursing home paperwork. It doesn't say anything about arbitration. So why should we not look at this carefully through the lens of Manor Oaks and conclude that the authority wasn't provided?
Well, let me make one position clear as far as the appellees are concerned in this case. We are not taking the position that a healthcare surrogate has the authority to sign an arbitration agreement. We are fully aware that there is a plethora of case law out there in the state
Right.
of
Well,
Florida.
we spent a lot of time in the briefing on
Right.
healthcare surrogates. That is basically from the prior argument, a red herring here, because this power of attorney goes beyond healthcare surrogacy.
Correct. And I agree with Your Honor. As this court decided in the Jaylene case, Jaylene versus Moots, back in 2008 at 995 Southern 2nd, Southern 2nd at 566, this court held that a POA, a power of attorney, need not expressly refer to arbitration to confer authority to agree to this method of dispute resolution. So whether or not there was any reference in the admission agreement or the arbitration agreement or the power of attorney for that matter, specifically relating to an arbitration agreement, I don't believe is necessary for this court's interpretation. I would also make a notation to the court that this power of attorney, durable power of attorney, is interesting in that it is separated into two parts. One part is Article 1 and Article 2, which is separately executed. And then it goes on to, as Judge LaBritte indicated, Articles 3, 4, and 5. It's the second portion of that durable power of attorney. I dare say that if we were only evaluating Articles 1 and 2, we probably wouldn't be here today discussing these issues. But the power of attorney goes on beyond the issues of healthcare and considers a number of other elements and factors that expand the power of the attorney, power of attorney in the agent in this case. And Your Honor, Judge LaBritte focused on a number of those. And I won't go into too much detail, but for example, resort to the courts, Article 4, Paragraph 4E, execution of documents, Article 5, Paragraph B, relates to any contract. The agent can execute any contract. It's not limited to any specific contract. The agent is allowed to grant releases to hospitals, physicians, nurses, other medical and hospital administrative personnel. Companionship. The agent is able to provide for such companionship as the grantor needs and prefers. I would point out to the court that under Florida law, the Agency for Healthcare Administration defines a companion as a person who provides tasks such as cooking, running errands, and housekeeping. Under statute 400.462 subsection 7, a companion is not able to provide medical care. There's another section that provides for funeral arrangements. Funeral arrangements are most certainly not within the realm of providing medical care. This goes beyond a healthcare surrogate who makes decisions, medical decisions, as to what treatment should be rendered and what treatment should be withheld under certain circumstances. Now, the Manor Oaks and Irons cases, we believe, are very limited in relationship to the durable power of attorney that we have here. In Manor Oaks, that was decided in 2019, and that was also an attempt and it was argued that a healthcare surrogate was broad enough to allow the surrogate to consent to an arbitration provision in a nursing home admission form. Again, going back to my original position, we are not making that argument in this case. Moreover, the Manor Oaks case noted that the term healthcare surrogate was referenced over 20 times in that durable power of attorney. That's not our position in this case. Similarly, in Irons, that case was decided by this court in 2011. Mrs. Irons resided for about a month at Dove Healthcare, which is a skilled nursing facility in Arcadia. Within days of her discharge, she unfortunately passed away. Mrs. Irons' daughter was provided with a healthcare power of attorney. She signed an arbitration agreement. Later on, she filed a lawsuit. The court found no authorization in the healthcare surrogate to enter into the arbitration agreement. But as Judge Silberman pointed out, in the Irons case, specifically, there's a provision that provided that I alone, meaning Mrs. Irons, the grantor, not my surrogate, shall be liable for signing admissions for treatment papers for my health care. Clearly, that is not what occurred in this case. The Irons case, interestingly, noted the sovereign healthcare case that was decided also by this court in 2009. And in the sovereign case, which the trial court relied upon, in this case, a present case before the bar, used a two-prong and developed a two-prong analysis of a power of attorney. And this court found in that case, in the sovereign case, there were two specific grants of authority, consent to hospitalization and the ability to sign any and all releases for such hospitalizations. And this court found that those provisions were similar enough to the power to argue that an arbitration clause in a skilled nursing facility admission agreement should be enforced. I touched upon the Jaylene case, which is another Second District Court of Appeal case. I would like to then now address another issue in the alternative. I think there's ample opportunity and ample factors for this court to consider that the durable power of attorney in this case goes well beyond just healthcare. But as an alternative, I'd like to raise the equitable estoppel argument. Equitable estoppel has been around for centuries, steeped in the common law. The most revealing document in this case appears in the appellee's appendix 2, page 39. And I apologize to the court profusely. There was a mistype page number. It states appendix 2, page 35. It should be appendix 2, page 39. And that document, which was among a number of other documents signed by Vincent Alberico in this case, as a part of the admission process and admission packet, which includes consent for treatment, financial questionnaires, etc. But this document in particular is revealing because Mr. Alberico held himself out as the responsible party and legal representative for his father. And it states, I quote, I, Vinny Alberico, am the legal representative of Albert Alberico, a resident, and do hereby request that his personal funds be held, safeguarded, managed, and accounted for by this facility. I have filed with the administrator a copy of the documents which give me authority to handle this account, unquote. Now, we're not sure what documents were provided to the administrator, but more likely than not, it's probably the durable power of attorney that is before this court and is being considered. The appellees relied upon his representations that he was the responsible party and legal representative. As we cited in our brief, equity is the soul and spirit of the law. And it is to prevent a plaintiff from relying upon a contract when it works to his advantage and repudiating it when it works to his disadvantage when requiring arbitration, as an example. Businesses such as acute care facilities, hospitals, urgent care centers, physicians, and nursing homes should have a right to rely upon the representations of those coming before them and claiming that they are responsible parties, they're legal representatives. And otherwise, it destroys the entire fabric of the business relationship. Carrying this to its most extreme but logical rationale and extension, if we have a plaintiff who brings a lawsuit for wrongful death or for medical malpractice, and a power of attorney signs off, or a responsible or legal representative signs off on the medical consent form to provide medical treatment, not only does that plaintiff now have a potential cause of action for the negligence of medical malpractice, but they can go back and say, oh, well, I did not have the authority to sign that medical consent. You provided medical treatment and care to my loved one without that consent. So now I'm going to hold you and bring an action for civil damages for assault and battery. So we have a right and should have a right as a nursing home facility or any healthcare facility to rely upon the representations of those coming before us and asking for care and treatment. Equity requires no less. And other than that, I rely upon our answer brief in this case. Thank you for your time. I appreciate it.
Very good. Thank you very much, Mr. Thomas.
Yes, Smith, please court. With regard to defense or the appellee's counsel's referral to Jaylene, both Altera and Jaylene were decided based on the fact that in the pre-2011 changes, statute section 709.08 existed, specifically subpart 6, which gave the power of attorney a statutory authority over property rights and control of property, including choses of action. That formed the basis of the court's opinion in those cases. That statute no longer exists. There is no longer a statutorily created right of property. That has to be specifically laid out pursuant to the statute, as we were discussing. 709.2201 said general provision. First, an agent may only exercise authority specifically granted to the agent in the power of attorney. And then they have the exception of those that are reasonably necessary to give effect to that express grant of authority. And then the exclusion of all general provisions in a power of attorney which do not identify the specific authority granted. In our power of attorney, we have in each of the 4 articles and in the powers conveyed in the first 3 paragraphs, limitations, define limitations, these powers as to my health care, my medical care, powers as to care. When we talk about the care that's permitted to put someone in a nursing home, a hospital, you go through the convalescent home, the whole list of facilities listed are all of the healthcare type. And we judge a word by its company. And that is the type of places that are covered in that provision. With regard to companionship, it requires disability precluding the grantee from having the ability, or excuse me, the grantor from having the ability to take care of that himself. And that's in the express terms of the power of attorney. With regard to the case law, when we take a look at everything from Jaylene, from Manor Care and State of Irons, we find that authority over health care, the authority to contract for admission to a nursing home, has been held to not include dispute resolution or agreements to waive right to court, access to court, and agree to an arbitration provision. That's in those cases. Now, with regard to the arguments by counsel with regard to equitable estoppel, our reply brief goes into detail the fact that there is insufficient record evidence or a total lack of record evidence as to any representation by the grantor, who would be the principal of the agent under a agency by estoppel kind of argument. There is no representation. Peggy Falls, the only witness in the hearing, testifies she has no recollection of any conversations or interactions with either Mr. Alberico or his sons. And in fact, the document that counsel refers to, signed by Joseph or Vincent Alberico, basically acknowledges that he's provided the power of attorney to Peggy Falls, the director of admissions. Peggy Falls testified that she had received the power of attorney. So any such limitations, the extent of the authority that Vincent Alberico had expressly contained in that power of attorney, can't be defeated because he complied with the power of attorney. And there was no representation by his father, the grantor, that was relied on to their detriment. In addition, it was not a required provision for the admissions contract. It's a separate agreement. It's optional by its own terms. And so there was no detrimental reliance, which is another element of this alternative theory that the defense has. If there aren't any other questions, the appellant relies and refers back to the initial brief and the reply brief, and we rely on our argument contained therein.
Very good. Thank you very much, Mr. Thomas and Mr. Silverberg.
Thank you, Your Honor.
You're welcome. The next case on the oral argument docket